Hi friends, I Srinath Pandav welcome you all to CSC Specialist. Today's topic is citizenship. In this topic, we see the difference between the citizen and alien. Then we see the process for acquisition of citizenship, the process for losing of citizenship, the Citizenship Amendment Act 2019, and the NRIs, OCIs, and others. Indian Constitution categorize individuals as citizens and aliens. Citizens are the ones who are full-time members of Indian state, and these citizens enjoys the privilege of civil and political rights. And aliens are the ones who are referred to as foreigners. They are not born in this country but entered the country through legal means. For example, through valid passport and visa. Aliens are further classified into friendly aliens and enemy aliens. Friendly aliens are those individuals from country with which India has or shares cordial relations. For example, USA, France, Britain. And enemy aliens are those individuals from those countries with which India has been to war or does not share friendly relationship. For example, Pakistan. In India, there is single citizenship, which means individual is the citizen of country alone, and there is no concept of being a citizen of particular state. And also single citizenship means the citizen cannot hold other country citizenship simultaneously. It means India, we are the citizens of India only, and there are states. There is no concept of a state citizenship, only we have the concept of Indian citizenship. Single citizenship also means that citizen cannot hold other country citizenship simultaneously. If citizen of India is holding the citizenship of India, then he cannot be a citizen of other country. But in many countries they follow dual citizenship, but India follow single citizenship. The dual citizenship can be seen in USA. In USA, individual is not only the citizen of country, but he or she also holds the citizenship of particular state or province. Hence, single citizenship is the peculiar character of India. The Indian Constitution mentions who can be the citizen on 26 Jan 1950, the day Indian Constitution got implemented. Here, Indian Constitution speaks about four categories of people. The first category of people are those people who are residing in India are Indian citizens. The second category include descent of undivided India, that is India gave primacy to descent, that is just sanguineous, over place of birth, is just solely. And the third category include those who have migrated from Pakistan to India can have citizenship. And the fourth category are those who have migrated from India to Pak but have returned back to India, have Indian citizenship. So, Indian Constitution mentions who can be the citizens on 26 Jan 1950, the day Indian Constitution got implemented. Here there are 4 category of people. Those people who are residing in India, they can have the Indian citizenship. Descent of undivided India and Pak, and those who have migrated from Pakistan to India, they can also have the Indian citizenship. Those who have migrated from India to Pak but have returned back to India, they can also have the Indian citizenship. It is on the day the constitution got implemented. The important point to note is constitution does not provide details on how to acquire citizenship or lose citizenship. In this regard, constitution says power has been given to Indian Parliament to bring law with regard to acquisition and termination of Indian citizenship. Hence, Parliament enacted Citizenship Act 1955 and later it got amendment in 2019. So let us see the Parliament Act 1955. Here it talked about the acquisition of citizenship and termination of citizenship. In acquisition, there are different ways through which the citizen can acquire Indian citizenship. The first way is by birth, then by descent, third by registration, fourth by naturalization, and fifth, if India acquires any territory, President by order provides citizenship. These are the 5 ways through which a member can acquire citizenship. Article 5 of Indian Constitution says that citizen right at the time of commencement of Constitution. And Article 6 says that citizens, those migrated from Pak to India. And Article 7 says that citizens, those migrated from India to Pak and return back. And Article 8 says that person of Indian origin right residing outside India at time of commencement of Constitution. And Article 9 says automatic termination if acquired foreign citizenship. From the Article 5 to Article 9, the citizenship is mentioned in Indian Constitution. Article 10, it is law application to citizen made by Parliament. And Article 11, Parliament power to make law with respect to acquisition and termination. Hence, law was made in 1955 and this was amended various times in 1986, 1992, 2003, 2005 and 2019. Parliament Act, what we study is by birth, by registration, by acquisition, by naturalization, by descent. Hence, this is through the Parliament Act. Let us see the citizenship through Parliament Act, that is by birth, by registration, by acquisition, by naturalization, by descent. Here we can remember it as a brand. First one, by birth. A person who is born in India and born on 26 Jan 1950 and before 1st July 1987, just by place of birth the person can become Indian citizen. Then a person born on or after 1st July 1987 till or before 3rd December 2004 if born in India, either of parents to be citizen at time of birth, that is the mother or father to be a citizen of India at the time of the child's birth. Third condition is person born on or after 3rd December 2004 to be born in India, both parents to be citizen of India. If one parent is citizen and other parent is not a citizen, then it leads to consider as illegal migrant. And legal migrant is defined in 2003 Act, the person having valid passport and returning country before the permitted limit, then they are considered as the legal migrant, or else to illegal migrant. Then by descent, that is born outside India. Here a person born outside on 26 Jan 1950 and before 10 December 1992, the person can become citizen if father is citizen at time of birth. Then the second condition is if a person born on or after 10 December 1992, either of parents to be citizen of India. Here the point to note is the descent is not automatic because the person is born outside India. Hence the procedure is the parents has to declare that the minor not hold passport of other country, and the birth of this minor has to be registered with consulates within 1 year. After 1 year, the minor can become citizenship only through permission of central government. Hence the descent is not automatic. There is a procedure which there needs to be followed. Then third is by registration. Here if person having any relation with India or Indian citizen, like person of Indian origin, spouse, children of Indian citizen, then they can have the Indian citizenship through registration. Fourth, by naturalization. It is meant purely for foreigners. Here the foreigner should have knowledge of any language mentioned in 8th schedule, and the foreigner should be resident from making application. The person should have stayed in India for 12 months, and also the other condition is stayed in India for 11 years in last 14 years, and government can waive any of above requirement if person has distinguished achievement. Hence in naturalization it is purely for foreigners. The foreigner to become an Indian citizen, he should have knowledge of any language mentioned in the 8th schedule, and also he should be a resident, stayed in India for 12 months and stayed in India for 11 years in last 14 years. He or she can get the citizenship through naturalization. And the third condition is government can waive any of the above condition if person has distinguished achievement. And the last one is citizenship by acquisition of territory. Here president by order provide citizenship. Now let us have a look on losing of citizenship or termination of citizenship. Here there are three conditions. One is termination, that is automatic losing of Indian citizenship. For example, M.F. Hussain, who was a painter, acquired the citizenship of Oman, hence he lost the Indian citizenship. Then renunciation. It is the self-proclamation to renounce the Indian citizenship. Here the point to note is that minor child of that person also loses citizenship, but when such a child attains the age of 18 may resume Indian citizenship. The third is deprivation. It is government taking away citizenship. Here deprivation is done by the government if there exists fraud citizenship, disloyalty to Indian constitution, person communicated with enemy unlawfully during war, and apart from that, citizen within 5 years after registration or naturalization been imprisoned in any country for 2 years, the government can take away the citizenship. And also citizen been ordinary resident out of India for 7 years continuously, then government can take away the citizenship. These are the conditions for losing of citizenship or termination of citizenship. Now let us look at the Citizenship Amendment Act 2019. This act amended Citizenship Act of 1955. The act says those who have come from three countries. The three countries include Pakistan, Bangladesh and Afghanistan, and belonging to 6 communities, especially the Hindus, Sikhs, Jain, Buddhist, Parsi, Christ, are eligible to become Indian citizenship through naturalization even if they are illegal migrant. That is, the act says those who come from 3 countries, that is Pakistan, Bangladesh and Afghanistan, and belonging to 6 communities, Hindus, Sikh, Jain, Buddha, Parsi, Christ, can become an Indian citizenship through naturalization. And the cutoff date for this was December 31, 2014. That is 5 years before this Amendment Act. And the naturalization reduced to 5 years. And these people to be religiously persecuted residents. What was the government logic to bring this act? Since Pak, Afghanistan and Bangladesh are Muslim dominated and theocratic countries, hence there exists harassment of minorities in those countries. Hence, to address this issue, Government of India brought this act. But there exists criticism for this act, and the criticism was mainly from 2 categories. One is from mainland India and through northeast. The mainland India problem was mainly the protest was led by Muslims and minor parties. The criticism they gave are it violated principle of secularism, it violated Article 15 and Article 14 of Indian Constitution, and also asked that why Muslims have not been considered, especially the Ahmadiyas who are minor Muslims. And the response the government gave was no link between secularism in act, as government identified 6 communities. Article 14 and Article 15 are applicable only to citizenship. and Muslims of any part of world can become citizenship through naturalization. This mainly focused on minorities, and for not including Ahmadiyas, government responded that the act has been brought for religious persecuted persons and not the sectarian persecution. And when asked about the Myanmar, government replied that as of now we have focused on these three countries. Further, we can move on to the Myanmar. And the second protest was from Northeast. The Northeast protest was done because of NRC. Assam was the only state where NRC was done, hence it was easy to identify Indian citizenship and illegal migrants. NRC was important to Northeast because after the Bangladesh Liberation War, there was more influx of refugees for asylum. But these people remain in the Northeast India, affecting the cultural and ethnicity of Northeast. This leading to the demographic changes in the Northeast India. Hence, the Northeastern have protested. It was the Citizenship Constitutional Amendment Act 2019. Let us look on the NRI and OCI, that is non-resident of India and overseas citizenship of India. NRI are those Indian citizens currently residing outside India continuously for 6 months. These NRI enjoys the right of Indian citizenship. Overseas citizenship of India are the ancestors are Indians, but now they are not citizens. Hence, the son or daughter of these ancestors can have the OCI. OCI card holder has certain privileges than the foreigner have. NRI enjoys the voting right in India. He or she can occupy constitutional post. Hence, in all respect, he or she is Indian citizen, but residing outside India. And when we look on OCI, there exists a OCI card, and this OCI card was implemented in 2005. It is mainly given to people of Indian origin, and OCI card holder will be registered under Section 7A of Citizenship Act 1955. There are people who are eligible to be registered as OCI card holders. The people include anyone who was citizen of India at any point of time after commencement of Constitution in 1950. Then the other category include those who were eligible to be citizen of India on 26 Jan 1950, and anybody who belonged to territory that became part of India after 1947. It also includes various other category of persons. And another point is that as per Section 5 of Citizenship Amendment Act 1955, any person who is registered as an OCI card holder for 5 years and who is ordinarily resident in India for 12 months can make an application for Indian citizenship, and these OCI cannot vote and cannot occupy constitutional post. And the important point to note in the citizenship topic is, in India, naturalized citizen can become a PM or president, but in USA, only citizen by birth can become president and not naturalized citizen can become a president. Now let's have the recap. In citizenship chapter, we have seen the difference between citizenship and alien. In alien, we have seen the friendly alien and enemy alien. We have seen the citizenship mentioned in Indian Constitution, especially the citizenship on 26 Jan 1950, where we have seen the 4 categories, that is resident of India, descent of undivided India, those who migrated from Pakistan to India, those who migrated from India to Pak and then returned back to India. Then we have seen the Article 5, that is citizenship at the time of commencement of Constitution. Article 6, citizenship of person migrated from Pakistan to India. Article 7, person migrated from India to Pak but returned back. Article 8, person of Indian origin residing outside India at time of commencement of Constitution. And Article 9, we have seen the termination of Indian citizenship. Article 10, law application to citizen made by Parliament. Article 11, Parliament power to make law with respect to acquisition and termination. Hence, Indian Constitution has the mention of the citizenship on 26 Jan 1950, but Indian Constitution conferred the power to Parliament to make law on citizenship, and Parliament brought the law of Citizenship Act 1955, where we have seen the different ways to acquire citizenship and different ways to terminate citizenship. In acquisition of citizenship, we have seen the brand, that is by birth, by registration, by acquisition of territory, by naturalization and by descent. And in termination, we have seen that 3 category. One is termination, second one is deprivation, and third one is renunciation. And after this, we have seen the Citizenship Amendment Act 2019, where the three countries, especially the Pakistan, Bangladesh and Afghanistan, and 6 communities, Sikh, Parsi, Buddha, Jain, Christ and Hindu, can become a naturalized citizenship, and the naturalization has been reduced to 5 years. And also at last, we have seen the difference between NRI and OCI, where in OCI we have seen the OCI card holders and the various provisions of NRI and OCI. So friends, I feel that I made this topic understandable to you, and if you liked this initiative, hit the like button, and for further updates, subscribe the YouTube channel. Thank you friends.